Hello friends, what options you have if police is not registering your FIR? That means they are not taking action on any of the alleged criminals against whom you have complained. So what options legally you have? Let us discuss about it today. Let me explain you. See, the first option is as per the judgment of the Lalita Kumari versus State of UP. This is a Constitution Bench judgment of the Honorable Supreme Court of India delivered in the year 2013. The Honorable Supreme Court has issued directions to all the DGPs of all the states in the country and also the union territories, so that with directions whenever a cognizable offense is being complained, or else whenever you make a complaint to the police officer which discloses the commission of a cognizable offense, then the police officer is duty bound to register an FIR. And the veracity of the complaint is not important. You might be giving a false complaint, but doesn't matter. Police officer do not have any rights to preliminarily make an inquiry whether that is a false case or a true case. He has to first of all register an FIR, is duty bound. Otherwise, he is liable for contempt proceedings as per the judgment of the Honorable Supreme Court in Lalita Kumari. Okay, you can file a contempt petition in the respective high courts under Article 215, read with Contempt of Courts Act 10 to 12, and the police officer will go to jail for 6 months, alright, for not registering an FIR. So he is duty bound. What is a cognizable offense? Cognizable offenses are offenses where the police officer has got full powers to arrest an accused without any warrant. Alright, he do not need any magisterial orders or permissions. If it's a non-cognizable offense, then he has to take a permission from the concerned court or of a judicial first class magistrate. Okay, now coming back to the point, the first and foremost thing is you have to go to the police station, make a complaint in writing. If they refuse to accept it, immediately go back to your home, immediately shoot a letter to the SHO concerned of the concerned police station with your complaint, with a registered post acknowledgement due. You need to get that acknowledgement card back to your home. First step. Second step is shoot the same letter to the superintendent of police. In cities, he is called Deputy Commissioner of Police. Both of them, the SHO and DCP, has got statutory liability under them, and they are bound by registering an FIR. If both of them do not register, then both of them are liable for contempt proceedings. Alright, now you have done the first step, taken the first step. They have refused to register your cognizable offense, and you have shot a letter to both of them. Second option, what you have now, what to do? Wait for 3 to 5 days. If it's urgency, immediately, if it's a very heinous crime like rape or murder or something where you need to collect the evidence immediately, so therefore you can immediately file a writ petition in the Honorable High Court under Article 226. You can move a lunch motion on the morning of the High Court, and they will hear it straight away by 2:15 or 2:30 p.m. and they'll pass an order for registering an FIR on a priority basis. If it is not that urgency, if it's a fraud or some other misappropriation or any other heinous crime, apart from rapes and murders where you do not need to collect a lot of medical evidence, then what option you have is you can move the court of judicial first class magistrate or second class magistrate, whomsoever is designated in that particular state or district or city wherever you are located. You can file an application under section 200, alright, CRPC. Erstwhile it is CRPC, now it has become section 210. So under this you have to file a private complaint. These are called complaints, these are known as complaints by examination of the complainant. And there is another judgment of the Honorable Supreme Court in Priyanka Srivastava, where the Honorable Supreme Court has mandated for provision of a affidavit in such kind of cases. So you have to provide an affidavit. There are 3 types of affidavits: verified affidavit, sworn statement. All these things you have to give it to the court. Then the magistrate again has got 2 options. Either he can refer the case under 156(3) CRPC is now 173 176 clause 3 CRPC. BNSS. So under this provision, the concerned judicial magistrate can refer your complaint to the police officer, the police station directly, ordering them to register an FIR and report the matter within a fortnight. That is what he can do. Otherwise, he can examine you on oath. If he is not satisfied with your affidavit, he can examine you on oath. And thereafter, if he is still not satisfied, he can, all the list of witnesses can also be examined by the magistrate, and he will ask you, you can produce one or two or minimum. After two, you can say, right now I do not wish to produce the further things, witnesses statements. Later on at the time of trial, I will be producing, or else at the time of after the registration of FIR, I am ready to produce. That possibility is also there. Then the judicial magistrate is also duty bound to refer the complaint if at all there is any prima facie case made out in your complaint, or if at all there is commission of offence in your complaint. So he has to refer the complaint to the SHO for registration of an FIR. And the same thing, after you wait for 1 week, instead of going under this section 200, you can directly go to the High Court, as I told you earlier, by a way of writ of mandamus, that is under Article 226, and you can pray the High Court to get the FIR issued. But in some high courts, it will become little difficult, because all the learned judges also will insist of, because you have to exhaust all your remedies before you come to the High Court. You have to go to the magistrate's court for a FIR. That is what they will say. But sometimes some people are lucky enough, if you have a good advocate and if you have a good point to present, and if your case has got a lot of gravity and police is deliberately not registering your FIR, and you want to save time, because it will take at least a month or two or more than that in the magistrate's court to get an FIR referred. If you want less than that time, then always the High Court is the better option for you. And in rarest circumstances, you also have a remedy, because it's a violation of fundamental rights. You can straight away go to the Honorable Supreme Court under Article 32 and file a writ petition. And if you need a CBI investigation also, only the constitutional courts like High Court and Supreme Court have got power to order a FIR with the CBI or Enforcement Directorate. So such kind of prayers are also possible through writ of mandamus, that is under Article 226. So these are all the options, and there is one more option. You do not want an FIR, because most of the cases police gets colluded with the other parties, the respondents and the accused, and they close the FIR stating that there is lack of evidence. They have almost 10 lame reasons which will claim one reason, lack of evidence or false complaint or what blah blah blah. They will close it off. So there is another option where you can insist on the magistrate to take cognizance under section 190 CRPC, that is now 200 BNSS. Taking cognizance means it's like almost charge sheeting. It is as good as charge sheeting. The magistrate will be taking cognizance of your complaint, but he will insist on at least 2 witness statements. Once you produce 2 witness statements along with the complainant statement, then the magistrate will take it on file. It's called taken on file. That means he has taken the cognizance under section 190 CRPC or 200 BNSS, and the opposite parties, the accused, will be charge sheeted, and thereafter either the magistrate can issue summons if it's a summons case. If it's a warrant case, then he can straight away issue warrants to the accused. So the courts are so powerful. The magistrate has got tremendous powers, sweeping powers you can say, which even the High Courts and the Supreme Court sometimes do not enjoy. When you go with a petition to the Supreme Court or High Court to take cognizance, they are not authorized, they cannot take cognizance. They can again direct the magistrate to take cognizance or to consider and take cognizance. That is the actual legal language. No court can directly take cognizance. There are certain instances where such kind of things happen and they got set aside with the Honorable Supreme Court, because that is the procedure alright laid down. In India, the cognizable offences issue is very tricky, because the police have been vested with sweeping powers when it comes to the cognizable offence. They are the only authorized people who can register a complaint, arrest the accused and prosecute the accused. But even the magistrates also have tremendous powers which they rarely use. If you want the learned magistrates to use those powers, you need to have a good counsel who can put all the facts, all the evidence before the magistrate and get favorable orders for you. In the lower court or the High Court, advocates play a very important role. You need to privately prosecute people, it's very important. the guilty has to be punished. If innocent should not be punished, at the same time guilty also has to be punished. That is the rule of law. All right, my dear friends, now I told you about all the options of getting an FIR registered. And last, you have the fantastic judgment from the Honorable Supreme Court of India in Amarnath Chaube versus Union of India. In this, the Honorable Supreme Court has categorically held that police no doubt has got sweeping powers and courts should not interfere with the investigation. But if the police is doing something wrong or fishy, then the courts have got bounden responsibility on them to put the police on right track and to direct them and to supervise the investigation, or else so that it will go in the proper way and the guilty should be punished. And this is because the right to fair investigation is a fundamental right now recognized by the Honorable Supreme Court of India by virtue of Article 14, which is equality before law, and Article 21, which is right to life and liberty. So these two articles have been quoted by the Honorable Supreme Court in this fantastic judgment of Amarnath Chaube versus Union of India. And one more thing lastly, if police have registered an FIR, they got colluded with the accused, normally 99.99% of the private complaints end up in police not charge sheeting the accused, because they find this private complaint as a very lucrative thing for them to fill up their pockets. They pocket very handsome money from the accused and they close it by saying 10 odd lame reasons, as I told you. They have a pro forma of 10 odd reasons, as I told you, lack of evidence, it's a false complaint, that blah, that this and all. Now, once the police closes the complaint, they are not authorized and it is illegal to close a private complaint. Why? Because if it is a crime which is registered directly by the police officers without the interference of the court of law, then they can straight away book a crime, they can close it at their wish, will and fancy. But they cannot do it with the magistrate's orders, magisterial orders or high court orders or Supreme Court orders. Why? Because these courts, once they find prima facie case, then only they will order an investigation. And once prima facie case is found, there are catena of judgments of the Honorable Supreme Court which states, like, once prima facie case is made out, the accused has to be charge sheeted. And there is no question of even quashing such kind of criminal proceedings. Whether it's an FIR or whether it's a charge sheet or whether it's taken on file, there is no question of quashing. That means High Court or Honorable Supreme Court will never interfere by quashing, and you have to undergo the trial. That is the rule of law. If prima facie case is made out, the accused has to undergo the whole trial and get acquitted or get convicted, whatever the court will deem fit. So there are judgments like Siddharth versus CBI and so, Dilawar Babu and other judgments also of the Honorable Supreme Court, which categorically say when a prima facie case is made out, the person has to be charge sheeted. There is no question of police officer closing the FIR stating that there is no evidence, because the magistrate is superior than the police officer, and he has already found a magistrate is not just a designation, he is a court of law. He is an honorable court, he represents a court of law. You will never say that magistrate has issued orders, you will always say that so and so number court has issued orders. So the court has got so much prominence. Even if a single sitting judge in an high court issue orders, you will never say that this so and so judge Saab has issued orders. You have to always say that the Honorable High Court of so and so has issued this orders. Even the same with the Apex Court also. The Honorable, there might be only two judges issuing an order, but you will have to say the Honorable Supreme Court has issued the order. So that is the legal standing. So my dear friends, I have already appraised you about how to take action in the cases where the police officers are colluded and they are corrupted and they deny your legal right, your fundamental right of right before law. Right to justice is also recognized by the Honorable Supreme Court, that it's a constitutional as well as a fundamental right, because right to equality before law is nothing but right to get justice. So you have all your rights intact, and the BNSS, Bharatiya Nagarik Suraksha Samhita, has provided you abundant amount of remedies. The same erstwhile CRPC also had good remedies. So you can utilize all these remedies, my dear friends, but the most important, always try to collect evidence. That is most important. Thank you, friends.